All right, today is the plea deadline date. What is happening?
Your Honor, the state made an offer of 6 years deferred adjudication.
Okay, I don't want to know what the offer is, counsel. That's supposed to be confidential. So today is her plea deadline date. Either she's accepting the offer or not. If she chooses not to accept the offer, then she's going to jury trial.
That's correct.
And we're going to give her a jury trial date.
Yes, we like a jury trial date, please.
All right, Ms. Ferguson, I need a jury trial date. How long will this take?
Probably a day, day and a half, Judge.
Okay. And it's one day, they're telling me.
I can either do next week or July 18th.
I'm sorry, I didn't hear that.
Next week or July 18th?
18. I have a vacation letter in for that time.
All right, we'll see you next week.
Okay.
right. What date next week?
And next week I have one in as well. Go up through the 16th and then I'll be back on the 19th or the 20th. You guys want to do that?
Yes.
All right.
Yes. And I'm good all the way to the first 2 weeks of July. Do that.
All right, Norma, can you put them in July?
And I can do July 5th.
That's fine. Thank you.
All right, we'll see you back on July 5th for your jury trial. You get a reset form and then you're excused.
Go have a seat. You'll take the team. There's too many people here in the area. That's right.
All right, Sarah Martinez Gallegos.
Sarah.
Good morning. Court is calling 2023 CR 4878W, State of Texas versus Sarah M. Martinez Gallegos. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Good morning, Judge. Dirk Ashball from Ms. Martinez Gallegos, and we are ready to proceed.
Are you Miss Martinez Gallegos?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
I have your honor.
Court will find that the state is in compliance with discovery. Ms. Gallegos, I'm going to show you a document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Did you understand you have a right to have a grand jury hear the evidence in this case? Your attorney has a right from 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for jury trial. Did you understand?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Showing you what's entitled Application for Deferred Adjudication. Did you review that with your attorney? Did you understand it?
Ma'am.
Counsel, I'm sorry. Next, I'm showing you what's entitled Information. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
Yes, Judge.
All right, and is this possession of,
Fraudulent use of possession, Judge.
okay, of identifying information?
Yes, less than 5.
All right. Did you understand the document entitled Court Admonishments? And did you review it with your attorney? And did you sign it in all the appropriate places?
Yes, I did.
Did you understand you're charged with fraudulent use or possession of identifying information less than 5? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
I did.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty, sentence you up to 2 years in the prison and up to, 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Judge.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Ms. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived a right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $250 fine. State recommends deferred adjudication. They will take in consideration JN 2123258. Did you understand that to be the plea?
Yes. ma'am.
Defense?
Yes.
Yes, Judge.
State?
Yes, Judge.
Did you review the paragraph entitled waiver of appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor. there-
Outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There'll be a TAP evaluation, 100 hours community service restitution, and the AIDS awareness course. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty,
No contest.
no contest? State any evidence?
State offers states exhibit 1 in all attachments.
No objection.
You may be excused.
Judge.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor. we are.
Anything you wish to say on behalf of your client?
No.
Judge, I'd just like to let the court know that my client just recently found out her dad passed, and so she is a little emotional this morning, but I think there's maybe an opportunity for her to turn her life around, and we just ask that the court follow that agreement, Judge.
All right. So how often are you using drugs?
For the past month, I haven't.
I'm sorry, what?
For the past month, I haven't.
Isn't that because you've been at the Bexar County
Yes.
Jail? So before you went to the Bexar County Jail, how often were you using drugs, and what were you?
Every
using?
day for about 2 years.
Every day, and what were you using?
Heroin.
Do you have any children?
I do, but they're all grown up.
All right, what are their ages?
21, 22, 18, and 17.
All right, so who does the 17-year-old and 18-year-old live with?
They're dead.
All right, have you had employment at all?
Not since I moved from Colorado the last time,
When's the last time you had employment,
3 years ago.
and what were you doing?
Taking care of my mom.
I'm sorry, what?
Taking care of my mom. I was a care provider.
Oh, okay. And yeah, you're not going to be allowed to be a healthcare provider anymore. You understand?
I do.
How far did you go in school?
I got a GP.
All right, so what are you planning on doing with the rest of your life?
I'm not sure yet.
How old are you?
I'm 40.
All right, it's time for you to figure that out. You understand?
I do.
All right, this is what the court is going to do. Is there anything you wish to say on behalf of your client?
I would just say, Judge, that you asked that you follow the plea agreement, Judge, and give her the opportunity to maybe get some help and turn her life in.
All right, 4 years deferred adjudication, $250 fine that'll be probated. take in consideration JN 2123258. Do you have any violent history in your past? All right, we're gonna do a referral to Esperanza Court. If they don't accept her, then it'll be felony drug court. That's gonna be while in custody. And I'm gonna want a TAP evaluation in custody. And if she's not accepted in Esperanza Court or felony drug court, then follow TAP recommendations. 100 hours of community service restitution. They want you to have the AIDS awareness course. They do have treatment for AIDS now, but they have something called super gonorrhea that there is no treatment. So no amount of penicillin will help you with that. So is there something for like STDs in general? You're gonna have to start, yes? All right, you're gonna have to start taking care of your body, you understand?
Yes, ma'am.
All right, proof of employment. Within 45 days of release, there's to be no employment as a home health care provider or with minors. I'm gonna want field visits one time per month until further notice. Regular reporting and the UA hotline. Probation, is there anything else she needs?
So for the ed course, STD course.
Yes. All right, you need to take that course. You're putting your life in danger whenever, one, you're using needles, and two, if you're engaging in prostitution. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes,
Is there anything else you need, court? Communication is key. If there's an issue, talk it over with probation. If you feel like probation isn't addressing that, then come back to the court. We're here Monday through Friday, okay?
I understand.
All right, good luck to you.
Thank you, Judge.
You're welcome. Who's here on Romero? Oh, thank you.
Thank you, Judge.
You're welcome. I'm sorry, sir.
It's good seeing you, Judge.
You too.
Take care.
All right, are you coming back?
I have not heard any word of any movement from.
Are you still in, are you in intake?
Yes, they have on today.
Okay.
It's just got brought to my attention. So when Brittany was out, I was like, let me just go take. it.
Oh, thank you. All right, why do I have the file on Stephen Ward?
Oh, I'm sorry, did you say Ward?
Yes, I don't know why I have this file.
Yeah, Jason Gosker.
Yes.
I just wanted to inform the court that that we got hired on this 2 weeks ago.
Mhm.
There is some outstanding discovery, no ads and some other things. And
Yep,
so,
we're scheduled for jury trial today, so I'll see y'all back at 1:30.
well,
Thank you.
Your Honor, we don't have the discovery, we can't be effective.
Well, here's the thing. This was set for jury trial. Your client knew it was set for jury trial. And everybody who gets hired on cases, they need to know when things are set for jury trial, it's set for jury trial.
I
This
understand.
case has been pending since September of 2022.
I understand, Your Honor, I just, I cannot make myself effective by 1:30 this afternoon. And
All
so-
right. Well, we'll see what happens. See y'all at 1:30.
Yes, Your Honor.
Thank you. You gotta be breaking. 12:30. 12:30. Yeah, 12:30. All right, who's here on Jacob Garcia?
I'm present, Your Honor.
Thank
Jason
you.
Goss.
All right, court is calling 2022 CR 16154. State of Texas versus Jacob Garcia. Again, that's 2022 CR 6154. Could I have parties announced for the record for the state?
Thanks to the state of Texas.
Defense,
Jason Goss for Mr. Garcia.
are you Mr. Garcia?
Yes, Your Honor.
Counsel, have you received all the discovery and did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Garcia, I'm showing you what's entitled application for deferred adjudication. Did you review that with your attorney? Did you understand it? Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor. I will point out that there's an amendment to the.
Yeah, there's a step to this. So are you waiving the reading of the indictment?
Yes, sir.
State, are you proceeding on the indictment as presented?
Your Honor, the state moves to make a motion to the indictment, or make an amendment to the indictment.
All right. Defense, have you ever chance to review the state's amendment?
Yes, sir.
Do you have any objections?
No, Your Honor.
All right, state, what are you amending in the indictment?
Your Honor, the state moves to amend the indictment to add a count two. Count one will remain as is, but the count two will be for stalking. And it's laid out in the motion to amend, and then at that point, the state would further move to amend to proceed only on count two.
All right, so you're doing a count two stalking,
Yes, Your Honor.
and that doesn't even exist anywhere in the indictment.
That is correct.
Well, Your Honor, it does. If you'll see count two, the first paragraph of count two.
No, I mean, the original indictment.
It uses.
So you're creating a new charge.
Yes, Your Honor. We have no objection to that. And we waive any indictment by the grand jury.
Just a second. All right, so if somebody can bring me some case law, but and I'll do some research very quickly on my own, but I don't think, even if they are waiving, I don't think you can create a whole new charge in felony court and say, we're doing this entire new indictment without an indictment, and it's nowhere in any of the indictments that's been filed. There's no way to get a lesser included of stalking out of it. And everybody's just doing an entirely different indictment. I understand there's some ways to do this when it is an information, but I don't see how you get stalking when the indictment doesn't have anything to do with stalking at all. The indictment is all sexual assault. So is there some case law for me that
Well,
somebody has?
Your Honor, I believe what the case law says ultimately is when the defendant gets the benefit of the bargain and has no objection, then he has no right to appeal or to object later on. However, if the court saw the indictment amendment as an information, and this was looked at by the court as a waiver file or a waiver case, As the court knows, it's common for the defendant to do a waiver with, as you said, the information.
No, I understand that with the information. I understand what you mean with the benefit of the bargain, but the benefit in the bargain does not apply in every case. So just give me a moment. I'm going to do some research very quickly. So if y'all have a seat and I'll see if this can be done.
Yes, Your Honor.
All right, thank you.
Your Honor, may I, if I may, the complainant in this case, was asking if, this sentencing could happen tomorrow so that she could be
Okay.
present for a victim
Sure.
impact. I just wanted to make the court aware.
All right, thank you. And let me just look at some case law. Okay. All right, as soon as the court reporter comes back, we'll take this up.
Would you like me to sit back down?
Yes.
Okay.
Okay, all right. Can I see the parties on Jacob Garcia? All right, we're back on the record in 2022 CR 6154. States you're requesting to amend the indictment
Yes,
and you're requesting to amend it to stalking
yes, sir.
and defense. You have no objections?
We have no objection.
All right, Mr. Garcia, you are under oath. And the court previously indictment is a completely separate charge.
Your Honor.
And you understand that your counsel has 10 days to prepare for trial since this is a completely separate charge.
Yes, Your Honor.
All right, knowing that, do you still wish to proceed? All right, and do you understand? I'm sorry. One other thing I want to put on the record. You are waiving your right for your attorneys 10 days to prepare,
Yes.
and you are waiving the right of ineffective assistance of counsel by entering this plea. All right. Is there anything else? The court will grant the motion. Is there anything else that either side wishes to place on the record?
Your Honor, for the record, the state will move to only proceed on count 2.
Mr. Garcia, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand with the amendment, the state is proceeding on the offense of stalking? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
yes,
Do you believe he's currently competent, was legally sane at the time of the offense?
yes,
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargaining agreement, the state is proceeding on count 2. They're recommending deferred adjudication, and they're recommending an affirmative finding of family violence.
Yes,
Do you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
I can't. Yes, Your Honor.
All right. Did you understand that to be the entirety of the plea?
Yes, Your Honor.
Defense,
Yes,
state?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
well, none ruled upon.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 4 years. There be 150 hours community service restitution and no contact with the complainant. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to count 2 of the amended indictment, how do you plead? Guilty, not guilty, or no contest?
No.
State any evidence?
State offers State's Exhibit 1 and its attachments.
Any objections? Mr. Garcia, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after viewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. And when will the person be available?
Tomorrow.
All right. We'll come back on June 8th for sentencing. Tomorrow. I'm sorry, the 7th. We'll come back tomorrow for sentencing on the 7th.
Yeah.
What time you're on?
9.
If the dog anymore.